Welcome to this session on understanding the PROMAC performance management model. My name is Ivor Blumenthal, and I really appreciate the opportunity of engaging with you on this topic. So, the performance management cycles for competency management at PROMAC basically imply the following: that the first of these cycles, and there are 3 cycles, by the way, is called the management cycle. Ideally, we never want to get out of that management cycle. We always want to be in the process of determining how you are performing and then affecting your bonus and your increase based on our assessment of your performance. The second is the counseling cycle. This is when it comes to competency, your competency as an employee of the organization, we have to say to you, we've tried to exhaust our obligation as an employer to you. We've tried to train you. We've tried to induct you. We've tried to coach you. We've tried to mentor you. It's still not coming right. And therefore, we have to move to the counseling phase of performance management. And then, of course, the third cycle is the cycle that we would refer to as the disciplinary cycle. This is the stage where, if it's about competency, we really have to question whether or not you should be an employee in the company. So the important issues one has to consider when it comes to performance management is, first of all, distinguishing competency from behavior. And we're going to say a lot about this in slides to come. The second is that we're looking to minimize a step-ladder approach to discipline. So while the Labor Relations Act talks about progressive discipline, we say that when it comes to your competency, then of course we need to exhaust the obligation. And more importantly, we need to, through a process of coaching, through a process of counseling, and maybe through first and second written warnings, get into a step-ladder approach to, if we ever need to finally get to discipline, to be able to say that we have followed a progressive process of discipline to get to the discipline cycle, and it's severe. The consequences have to be severe if we are, in fact, in the disciplinary cycle. An important issue to consider in any performance management system is that the functionality of a grading system is more important than whether or not we call the grading system Patterson, Peromnes, or Hayes, or any other label such as, for example, Castellian, which, by the way, for those of you who drink beer, Castellian as a grading system in South Africa was developed in South African breweries, and as it suggests, is a combination of the 2 brands, Castle and Lion. A job description is management's instrument, which directs the induction process, the performance appraisal process, measurability of performance, quality feedback, training, counseling, and where we discharge the managerial onus towards the employee. And then, of course, is the foundation of support and evidence when one moves into discipline and possibly even dismissal for an employee who's just not getting the grasp of the job, irrespective of how the company has been trying to exhaust its ongoing obligation. So we want to talk about the difference between competency and behavior. A competency problem relates to a lack of the necessary knowledge or skills which are required to perform a job. A behavioral problem is about a negative attitude, a negative behavior, or conduct that violates company policy or values. A competency problem can be resolved through training, through coaching, and through a development program within the organization. But a behavioral problem requires a different approach. Sometimes it requires counseling, sometimes it requires mentoring. But the reality is that to suggest that how a person behaves could indicate counseling, mentoring, or even performance improvement plans is not something which is advanced within PROMAC. As far as PROMAC and any clear thinking company is concerned, How you behave is a cycle which is supposed to have been set as a child for you, in school for you, parented by your parents, in a society of moral values. The workplace is not a school. It is not a parent. And in fact, it is not a society outside of the work society. So any company where counseling, mentoring, and performance improvement plans are required when it comes to behavior, bad behavior, insolence, insubordination, failure to carry out a direct instruction from a supervisor, and violence and aggression towards your peers or towards customers or towards management, those are behavioral issues which do not, in the opinion of PROMAC, necessarily mean counseling, mentoring, and performance improvement are required. The employment contract, the job description, and company policy helps to determine whether a problem is related to competency or behavior. And quite frankly, in cases of misconduct, the employer needs to conduct a fair and reasonable investigation as to whether or not misconduct has occurred, needs to gather evidence, and needs to determine the cause of the behavior. And the employer has to follow progressive discipline with a verbal warning and progressing to more severe consequences if the behavior continues. But the reality is, an employer does not have to bend over backwards when accommodating a behavioral problem in the employee to the same extent that it does if that is a problem of competence. It is essential for employers to document disciplinary action and to keep accurate records to defend legal challenges where necessary. Now, as far as job grading is concerned, in this company, we look to distinguish levels from A to F, and we might have sub-levels within a particular band. So the band C1, C would have sub-levels of C1, C2, and C3 for argument's sake. In the job grade, we look to distinguish responsibility. We look to specify job functions. We look to specify the education and experience we might require to make an appointment in the first place. We look to specify the education and experience we might require if we want to promote you as an employee. And we want to specify how you can advance beyond your job. Do you advance to other jobs on the same level? That's horizontal advancement. Or in fact, do we move you and do we therefore promote you upwards within the organization? That's vertical advancement. Now, as far as a job description is concerned, job description in PROMAC is a standardized document which is prepared by the Human Resource Department. It describes the job. It's broken up into key performance indicators, the things that you would be responsible for doing on a daily basis. We focus very much on the tools of how we're going to measure you. So, for example, a merchandiser within PROMAC should have a notebook or an iPad of their own. A research and development practitioner should have a reporting standard and a template provided to them by the manager of the research and development department. These are measurability tools. So, for example, again, with the merchandiser who's got a notebook, we can determine whether or not they've been doing their morning rounds, whether or not they've been looking at the shelves, and they've been making notes of stock shortages or stock rotations, which is required. The notebook becomes something that can be tracked by the field supervisor to whom the merchandiser reports at PROMAC. So it's a measurability tool. The measurability scale, on the other hand, the measurability scale is a scale which might be from 1 to 4 or 1 to 10, and basically is an indication of how acceptable the employee's performance is, or in fact is not. And then, of course, within the job description, one needs to talk about formalized training, which the company can offer or accepts, or continuous professional development, which will be offered by the PROMAC training institution within PROMAC itself as a group of companies. And the job description will indicate what I referred to a little earlier in terms of the grading system. It will indicate opportunities for advancement and also opportunities for promotion. So it's critically important that employees know and understand the contents of their job description. Now, equally, it is important that employees understand the disciplinary process. The fact that discipline is procedural and not only substantive. And that means that there is a set process that discipline follows. And before one can apply one's mind and one's discretion, one needs to satisfy. In fact, the labor court itself is focused on the procedural mechanisms that a decision was arrived at, as opposed to simply the decision itself. One of the principal procedural mechanisms is something in law which is referred to, and it's a Latin term, called audit ultram partem. Now, audit ultram partem means hear both sides of the story. And if you're going to discipline, not only do we want to know that the manager is heard in terms of how frustrated he could be, either with the lack of competency being developed with the individual, or alternatively with very, very poor and questionable behavior. Not only do we want to hear accusations from the manager, but equally we want to hear a defense from the employee. And so audit ultram partem characterizes at PROMAC the way that discipline takes place. Everybody is given a chance to speak and to have their say and to question what the other party says. Now, the role of employees in the disciplinary process, well, the employee has to understand that they have rights. So the principal rights are, for example, the right to be represented by a shop steward in the organization, if there's a shop steward in your department, or by another person in the organization from another department, the right to question evidence and question charges against you, the right to question witnesses, and also to lead your own evidence and bring your own witnesses to bear on your behalf as an employee who is accused in the disciplinary inquiry of having done something wrong. But equally, you have a responsibility as an employee, and that responsibility is to respond to what the manager or the company representative has to say about why you're there in the disciplinary inquiry in the first place. Responsibility is to allow the other party to be heard. The responsibility is to allow your witnesses to be questioned and your evidence that you want to lead to be questioned. And as far as grievances and appeals are concerned, your role as an employee is to exhaust the opportunity in your company for a grievance. In other words, to exhaust the internal mechanisms in the business before you go outside of the business. No appeal will ever be heard against the decision which has been taken if the process of appealing is not followed. And so that becomes a responsibility of the employee to follow the process for the appeal to take place. Practical example there might be if there's a rule that says you can appeal within 5 working days against the outcome of any disciplinary inquiry. So if you appeal in 10 working days, you've not followed the rules. You've not appealed in 5 working days. And if you were aware of the fact that there were 5 working days to the appeal, and you appealed outside of the 5 working days, don't expect a sympathetic ear. Unless, of course, you were in hospital and couldn't appeal, or you were in a position where you just were not able to appeal, in which case you'd apply for something known as condonation, and certainly the company would have to look favorably on your application for condonation if there's a good enough reason. Now, equally, the employers have a responsibility in the disciplinary process and a role. Again, it's about evidence, it's about leading witnesses, it's about cross-questioning the evidence and the witnesses of the employee who may be led. And importantly, the employer has to understand the stages of the disciplinary inquiry and not confuse them. And I'm going to talk about the stages in a little while. One of the roles of the employer in the disciplinary process is to apply the principles of suspension and dismissal when it comes either to issues of competency or behavior in a very fair and equitable way. One of the procedural mechanisms which is required if a manager is going to discipline is that there has to be a sound investigation into the charges against the employee. There has to be clear reasons for an investigation. There has to be a clean process for the investigation to take place. And the investigator, him or herself, has to be above reproach. They cannot be biased. They cannot show bias. And they have to take every step they can to make sure they don't show bias. Now, there are different kinds of penalties or disciplinary action which can result from a disciplinary inquiry. For example, that of receiving a verbal warning or a written warning or a final written warning, or being suspended without pay, or in fact being dismissed. So the result of disciplinary action will be a penalty which is imposed after, and it's the after that becomes very important. I'm going to elaborate on this, but there are two concepts. The one is mitigation, and the other one is arbitration. And it's after mitigation and arbitration has taken place that whoever is hearing the disciplinary inquiry and making a decision about penalty exercises their discretion and is prepared to be challenged on the exercise of their discretion about the penalties that they've chosen to impose. Internationally, the best practices in the disciplinary process is clean and clear communication to all sides and from all sides. It's timely action. It's not disciplining someone today for something that took place 6 months ago. That is not timely action. It is consistency. In law, it's something called precedent. In other words, if I have behaved towards one employee in one way for exactly the same charges, I have to be consistent and I have to behave in exactly the same way if the mitigation and aggravation factors are the same against the next employee. I have to be fair. I have to listen to all sides. And the tool of fairness is, would another chairperson of an inquiry have come to the same conclusion? Now, as far as discipline is concerned, training and development for an effective disciplinary process is very important. It's important that shop stewards are trained. It's important that managers are trained, that there are training and development programs to understand and to apply discipline to performing various roles. And it's very much like a court case. You are either a prosecutor or you're a respondent. You're a chairperson. You're a witness. And so these roles have to be inculcated, have to seep into the culture of an organization for it to be effective in the disciplinary process. And the thing about having a culture for fair disciplinary activity means that there always has to be space for continuous improvement in the policy framework of how performance management takes place in the organization. So inquiries go through typical phases. There is an introduction by the chairperson, which includes what we would refer to as points in limine. Now, point in limine could be that the employee decides that they want to ask for a lawyer to be present or an external trade union representative to be present, where the policy of the company says that you can only be represented by somebody else within the company or a shop steward. So that, for example, is a point in limine that needs to be cleared up front before the inquiry continues. Another point in limine could be, has fair notice taken place? Were you notified at least 24 to 48 hours beforehand, working hours beforehand, so that you could properly prepare your defense as an employee? Stage one of the inquiry is where evidence is presented, witnesses are presented, there is a response from the other side, and that's both sides, both the company, which is prosecuting the charge, and the employee who is in fact responding or defending against the charge. Both of those sides are entitled to present evidence, present witnesses, and cross-question the evidence and the witnesses from the other side. The end of stage one results in findings by the chairperson of an inquiry. Stage two is what we refer to as the penalty phase, which includes taking into consideration issues of mitigation and arbitration, and I will define those two words in a minute, and also coming to a decision as to which of those various penalties I mentioned earlier will in fact be imposed. And the final stage of a disciplinary inquiry is where the employee is notified in that inquiry, at the end of the inquiry, that whatever they decide about the finding of the chairperson and the recommendation and the final decision made in the company, they are entitled to appeal against the outcome of an inquiry within 5 working days, in other words, within a specific number of working days. And importantly, they need to be advised, the employee needs to be advised that ordinarily the two major grounds for appealing are that the chairperson didn't take evidence which was presented into account, or alternatively, that the punishment didn't fit the crime. Now, I'm going to tell you something now that's quite strange and very, very seldom understood. Both sides are entitled to appeal. What I mean by that is, if a chairperson's recommendation is accepted by the company, the senior manager in the company, that dismissal for argument's sake takes place, then the employee may appeal against that if they feel that evidence presented wasn't taken into account or the punishment didn't fit the crime. But equally, a manager who that person is responsible to, who feels aggrieved that maybe the employee wasn't dismissed, could equally appeal within 5 working days against the finding of the chairperson and the recommendation to the company, because they feel that the company maybe went too soft on the employee. So the appeal goes both ways. And the final thing I want to just very quickly say about an appeal is lodging an appeal sometimes is a little bit like gambling, in the sense that an appeal, if an appeal is heard and the company says, right, we'll give you the right to an appeal, it means the matter gets reheard by another person who's chairperson. But equally, the company reserves the right to say, well, we don't think that the penalty imposed by the chairperson was severe enough, so we'll impose a harsher penalty than what was originally imposed, because an appeal has been applied for. So I just want to very quickly talk about what progressive discipline is, because the Labor Relations Act says that progressive discipline is the way to go in terms of how we discipline and eventually dismiss someone. So progressive discipline is a process envisaged by the Labor Relations Act. It involves a series of corrective measures aimed at improving the conduct or performance of the employee. And the goal is to help the employee meet the required standard before considering more severe actions. The process of progressive discipline varies based on the violation or the offense committed. The disciplinary measures include verbal warnings, written warnings, final written warnings, suspension with pay, suspension without pay, and possibly dismissal. Dismissal with pay, or what we refer to as summary dismissal, which is dismissal without notice pay. Now, the Labor Relations Act requires that an employer must follow a fair and reasonable process before imposing any reasonable disciplinary action. And that means that the employer has the onus, the obligation to show that they've exhausted their obligation for fairness and reasonableness in how they've conducted their affairs as an employer and the decision they've made in terms of penalty. If an employee is dismissed, the employer must prove that the dismissal was for a fair reason and followed a fair process. And the employee has a right to challenge the fairness of the dismissal through the CCMA or a bargaining council only when they've exhausted the appeals process within the organization, which means that if you haven't exhausted, you didn't appeal against the outcome of the disciplinary inquiry and you went straight to the CCMA, the company is within its rights to turn around in limine at the beginning of any conciliation or arbitration at the CCMA or bargaining council and say to the commissioner, this individual employee was informed that they had a right to appeal, that they had 5 working days to appeal, the normal grounds of appeal, And yet they didn't appeal at all. They just came straight to you. So we're asking you, Mr. or Mrs. Commissioner, to send the matter back to the company so that the employee exhausts their obligation, exhausts the internal dispute resolution mechanism in the company before they come to the CCMA or the bargaining council. And by the way, those of you who are not aware, the CCMA stands for the Commission for Conciliation, Mediation, and Arbitration. Employers must ensure that the disciplinary process is consistent, objective, and free from discrimination or victimization. They have to be able to show this. Now, very often, a chairperson may very well be inclined to be biased against the employee, but it's in resting on the procedural pathway which they followed as a chairperson, where they can control against the bias, where they can show they've given audit outram partem to both parties to be heard, the right to be heard, the right to present evidence, the right to cross-question witnesses, and where they can show they've been equal between employer and employee. Even if they're inclined to be a biased chairperson, they are proving that in this instance, they controlled their bias. If you want to look for guideline documents, then you would look at Section 188 of the Labor Relations Act in terms of understanding discipline. You'd look at the guidelines on misconduct arbitrations by the CCMA. You'd look at the Code of Good Practice dismissal in Schedule 8 of the Labor Relations Act. And you'd look at guidelines on misconduct arbitrations by the CCMA. Please excuse that last bullet point. It is a repeat of the second bullet point. Now, penalties. It's important to understand mitigation and aggravation as the main motivator for the final penalty which is imposed. So the range of penalties includes a verbal warning, written warning, final written warning, suspension without pay, demotion, forfeiture of benefits, and then dismissal. Dismissal with pay, dismissal without pay, which is what we call summary dismissal. So that's the full range that can be applied by the chairperson in a disciplinary inquiry. But they take into account the following two things. They take into account mitigation factors, and then they take into account aggravation factors. Mitigating factors can influence the chairperson to impose a less severe penalty, such as the employee's previous record, years of service, or in fact, personal circumstances. Aggravating factors. So remember now, we found you guilty, and now we're looking at what penalty should be imposed. So aggravating factors can make the chairperson decide on a more severe penalty, such as the severity or the nature of the misconduct, repeated violations, repeated warnings, final written warnings which are in place, whether the 6-month or the year period for those warnings have expired or not, or the harm that is caused by the misconduct itself can be an aggravating factor. I just want to very quickly talk about this issue of whether you've got final warnings or warnings on file which may have expired. The fact that the life of a warning has expired doesn't mean it cannot be taken into account during the consideration of aggravating factors. Because if you had a warning for doing the same thing 1.5 years ago, and now you're doing it again, that is aggravating. You knew it was penalizable. You were previously penalized for it, and yet you're prepared to do it again. That's an aggravating factor. And the other thing is this, what else can be taken into account when considering aggravation is that if when you started in the job, you were absolutely competent or you became competent after training and you remained competent for 2 or 3 or 4 years, and now suddenly you've become incompetent on the same output, on the same key performance indicators, that's an aggravating factor because you know what should be done, you've done it before, and yet you've stopped performing in that particular regard. So in terms of competency, that's an aggravating factor. The employer must prove that dismissal is the appropriate penalty for a specific incident of misconduct. and that all relevant factors have been considered. And the employee has the right to challenge the fairness of the penalty, again, first of all, by appealing, and then through the CCMA or a bargaining council, as long as the appeal is lodged in the company within the specific and specified time frame. The employer must provide the employee with clear reasons for the penalty which has been imposed. So at the end of the disciplinary inquiry, the chairperson says, right now, I'm going to dismiss you with notice pay. And here are my reasons. And then says, right, you've got a right to appeal within 5 working days. The chairperson must give their reasons, and the company must restate the reasons as to why the proposal from the chairperson has in fact been accepted by the company. And now we come to an important factor, one of the last factors of my discussions with you. The relationship between the chairperson and the employer. The chairperson of a disciplinary inquiry has to be neutral and unbiased, or at least control their bias by being procedurally fair. The chairperson must conduct the proceedings fairly and free from influence by the employer or the company. The chairperson must ensure that the employee is aware of their rights and has the opportunity to defend against any allegation of misconduct, whether it's for competency or behavior. And the employer must provide the chairperson with all the relevant evidence and information before the hearing. The chairperson has the authority to summon witnesses, which means to call witnesses, and request additional information necessary to make a decision. The chairperson has that authority. And the employer has the discretion to accept or reject the findings and recommendations of the chairperson, provided that reasons are reasonable and supported by the evidence. The chairperson must provide a written report to the employer outlining the findings of the disciplinary proceedings and the reason why the penalty was imposed in the second stage of the disciplinary inquiry, which is the penalty phase. I hope that you've found something useful in this presentation, and that if you have any questions, you will submit those questions through to Carleen Becker at the PROMAC Training Institute, and we will endeavor not only to answer the questions for you, but for the rest of the people in the training session. Thank you very much for attending.